to everybody. Welcome to the class of the JCJ 2022 Telangana State, our state of Telangana. And anyone can, host should not read. Host should not read. Anyone can unmute and read what I posted on the screen. Anyone can unmute and read what I posted on the screen. The host should not read.
The distinction between most repeated questions.
Only that much is there.
Hello, sir.
Only that much is there.
No, sir. The distinction between common intention.
Sir, first question we see the distinction between common intention and it is just says yes, sir. There is no word.
Yes, without wasting time, this is the only the I made the thumbnail. Now, without wasting the time, now I will switch over to the M. Motamari. Be ready to present it. Your turn. Yes, now I switch on to the Motamari. I think this is your questions. Is it?
Yes, sir.
Srividya Motamari, Srividya, continue it.
Yes, sir.
Say loudly.
Yes, sir. Question number 1. For a defense of intoxication to escape criminal liability, the intoxication, option A, can be self-administered. Option B, administered against his will or knowledge. Option C, should not be self-administered. Option D, all of the above.
B.
Option?
B, I think.
Yes, yes. Option B is the correct answer. According to section 85, the person should be intoxicated at the time of the act or before the commission of such offense. This is a explanation for the particular question. Next question. In cases where the act involves a specific mens rea, in cases of intoxication under section 96 of IPC, option A, the existence of mens rea is presumed. Option B, the specific mens rea is not presumed. Option C, the specific mens rea depends upon the attending.
Yes. Unmute and read.
Yes, sir. Option C, the specific mens rea depends upon the attending circumstances and the degree of intoxication. Option D, none of the above.
Shoot. There is no negative marks.
No, actually, we can't see the entire screen of the present. Yeah, now we can see it. Okay.
I know that because I know how much screen you could see it.
No, you are giving a question paper with half answers. Then now you can't expect students to reply the entire answer without seeing the remaining answers also.
Now you shoot.
Yeah. In case of where the act involves a specific mens rea, in case of intoxication under section 86, the mens rea is presumed, then someone is not presumed. Depends upon attacking section, none of the above.
I say shoot.
Someone who has administered to him without his knowledge or against his will.
Yeah, just a minute. Yes, it has come. Host, give the answer.
Answer is option C. The specific mens rea depends upon the attending circumstances and degree of the intoxication. Mens rea is nothing but an evil intention, where section 86 says that offense requiring a particular intent or knowledge committed by one who is intoxicated. Next question. I think this is clear.
Say third question.
Third question. The doctrine voluntary non-fit injuria is contended in option A, section 97 of IPC, section B, section 88 of IPC, option C, section 89 of IPC, option D, all the above.
Section 87.
Section 87.
Act done above 18 years by consent.
No.
It was the particular doctrine is contained in all the
All
above
of the
sections.
above.
Yes. Nothing but voluntary non-fit injury is nothing but goodwill and compulsion. He who suffers no injury. I hope this is clear. The next question, fourth. The defense of consent applies to option A, the private wrong, option B, public wrong, option B, both A and B, option D, neither A nor B. Yes, if you know the answer, you can check.
Private wrong.
Private wrongs.
Yes, private wrong is a correct, right answer. And does consent was defined in IPC? One more question.
Yes.
Does the word consent was defined in IPC? No, it was not defined. Consent means something done deliberately and on free will. And next question, fifth question. A hanging man who hangs the prisoner pursuant to the order of the court is exempt for criminal liability by virtue of section option A, section 77 of IPC, option B, section 78 of IPC, option C, section 79 of IPC, option D, section 76 of IPC.
78.
Mistake
Yes,
of act
78.
done in good faith believes him to be bounded by law.
yes, very good. Section 78 of IPC is the correct answer. And this is one of the important question. Next, sixth question. Insanity as a defined means that a person at the age of doing an act by reason of unsoundness of mind is incapable of knowing. Option A, the nature of the act. Option B, that what he is doing is wrong. Option C, that what he is doing is contrary to law. Option D, either A or B or C.
Nature of the act.
Nature of the act. No, ma'am. Option D is the
B.
correct answer. Either A or B or C. The next question, seventh one. The consent is not valid consent under section 90. Option A, if given under a fear or injury or misconception of fact. Option B, if given by a person of unsoundness of mind. Option C, if given by a child below 12 years of age. Option D, all the above.
Yeah. All the above.
Yes,
All the above. D,
Yes,
all the above.
yes, all the above is the correct answer. Next one, eighth one. The maxim de minimis non curate lex means option A, law would not take action on small and trifling matter. Option B, law does not ignore any act which causes the slightest harm. Option C, law would not take action in serious matter. Option D, all the above.
Option A.
Yes. Option A is the correct answer. It was defined in section 95 of IPC. Where trifles mean unimportant things. Ninth question. The right of private defense is contained in option A, section 94 of IPC, section 95 of IPC, option C, section 96 of IPC, option D, section 98 of IPC.
96. 96.
Yes, 96. That is the question.
95. D
The right answer is 95.
95.
Option C, section 95.
Proceed, ninth one.
Yes, sir. 95 section is about act causing slight harm, and 96 about things done in private defense.
Private defense.
Okay.
Yes, 96 is the correct answer. 10th question. A is beating Z and Y jumps in to stop the beating. In the process, A intentionally strikes Y. As per section 71 of IPC, which of the following should be punishment? Option A. A is liable to one punishment for voluntarily causing hurt to Z and to another for blow given to Y. Option
Ma'am?
B. A is liable of one. Yes.
Could you please the screen, ma'am? Share the screen.
Which question that you are reading?
10th question.
That you did not say, that's why I did not scroll it. Proceed.
Yes, sir. 10th question. A is beating Z and Y jump in to stop the beating. In the process, A intentionally strikes Y. A, as per section 71 of IPC, which of the following should be the punishment? Option A. A is liable to one punishment for involuntary causing hurt to Z and to another for the blow given to Y. Option B, A is liable to one punishment for voluntary causing hurt only to Z. Option C, A is liable to one punishment for voluntary causing hurt only to Y. Option D, none of the above.
A.
Option A.
Yes, option A is the correct answer. The next question.
Say 11th question.
11th question. Okay, sir. Criminal intimidation by anonymous communication or having taken precaution to conceal where the threat comes is dealt under section. Option A, section 506 of IPC. Option B,
507 of IPC.
507 of IPC is the correct answer. It's a
Participants,
direct question.
please be patient. Let the host will finish the D option, then you can shoot. Okay, that you give the, before reading that you
And
give the
one more
answer.
supplementary question. Is 507 section is available or non-available?
Available.
Yes, it's available and non-cognizable offense. Very good. And 12th question. Sir, please scroll the screen.
Yeah, scrolled already.
Person for whose benefit or on whose behalf a riot take place, not using all lawful means to prevent it, is dealt under. Option A, section 155 of IPC. Option B, section 156 of IPC. Option C, section 157 of IPC. Option D, section 158 of IPC. A direct question. Option A is the correct answer. It was defined in section 155 of IPC.
Just a minute, because load is there. It is
Section
not,
155 is nothing but whenever a riot is committed for the benefit or behalf of any person who is the owner or occupier of any land.
इसका charge नहीं आपके
We deal with section 155 of IPC. 13th question. Personation
total
in
order.
election is dealt under.
SR
Option A,
Venunath,
section
mute.
171.
Sorry.
Option A, section 171 F of IPC. Option B, section 172 F of IPC. Option C, section 173 of F of IPC. Option D, section 174 F of IPC. Personation at election. I'll be saying one more word. Punishment for undue influence or personation at an election.
Ma'am, A, ma'am. 171 F of IPC.
Yes, 171 F of IPC is the correct answer.
Okay, ma'am.
When you read 171 capital F of IPC.
Yes, sir.
Next.
14th question. What is the minimum term of imprisonment in case of at the time of attempting robbery or dacoity? The offender is armed with a deadly weapon. He is punished with the imprisonment of not less than. Option A, 4 years under section 397 of IPC. Option B, 5 years under section 397 of IPC. 6 years under section 397 of IPC. Option D, 7 years under section 397 of IPC.
Ma'am, D, 7 years under section 7 of IPC.
7 years.
Yes, option D is the correct answer. 7 years under section 397 of IPC. And section 397 of IPC deals with robbery or dacoity with attempting to causing death or grievous hurt. One of the important question. Next question, 15th one. Which of the following is true about imprisonment? Option A, it is characterized by hard labor. It is characterized by confinement to jail. Option C, it is subject to the kind of imprisonment. Option D, all of above, all of them.
All of them.
Yes, all of them is correct answer. 15th question. In which of the following death sentence is awarded? Option A, waging war against the government of India. Option B, abating muting actual committed. Option C, murder. Option D, all the above.
Please scroll the question.
All of them.
All of the above.
No,
Yes,
clearly
all
visible.
of them is a correct answer. And 17th one. A gives Z 50 strokes with a stick. Here, A may have committed the offense of voluntary causing hurt to Z by the whole beating and also by each of blows which make up the whole beating. As per section 71 of IPC, which of the following should be the punishment? Option A. A is liable for every blow and should be imprisoned for 50 years, one for each blow. Option B. A is only liable for blows he delivered on the victim. Option C. A is liable to one punishment for the whole beating. Option D. A should be separately punished for beating and delivering blows.
Option C.
A,
A is
Option
liable
Option
to one
C.
punishment for the whole beating.
C. Option C.
Yes, yes. He may be beating 50 times, 100 times, but the punishment will only be for one time. 18th question. The word illegal is applicable to everything. Option A, which is an offense. Option B, which is prohibited by law. Option C, which furnishes ground for civil action. Option D, all of them.
All of them.
All of the above.
All of them.
All of the above.
All of them
Yes,
is the
all
answer.
of the above is the correct answer. And does illegal was defined in IPC?
section 43,
Yes.
ma'am.
Yes, very good. Section
Yes.
43 defines illegal.
Section
Nothing but legally
43,
bound to do.
yes.
19th question. A quarrel arose between C on the one side and A and B on the other. C abused A. Thereupon A strikes him with stick and B strikes him down with an axe on the head. Is it visible?
No, just a minute, because it's not supporting.
Okay.
Yes, go ahead.
A quarrel arose between C on the one side and A and B on the other. C abused A, whereupon A struck him with a stick and B struck him down with an axe on the head. He also received two other wounds with the axe on the other part of the body. Any one of three axe wounds was sufficient enough to cause death, especially the one on the head. Option A. C is guilty for voluntarily provoking the attack, while B is guilty of culpable homicide. Option D. A is guilty of culpable homicide, while B is guilty of voluntary causing hurt. Option C. B is guilty of culpable homicide, while A is guilty of voluntary causing hurt. Option D. Both A and B are guilty of culpable homicide.
Option D, ma'am. Both.
C.
Once again, read the question.
Madam, screen is not sharing, madam.
So, screen is visible to us. Slide your screen. Hope it is visible to all of you.
Yes, it's visible to everyone because I could see it.
And option C is the correct answer, where B is guilty of culpable homicide, whereas A is guilty of voluntary causing hurt. Kindly everyone mute yourself. And can
Ruhi
anyone say
Sakina, when you want to speak at the time, you unmute it.
Okay,
and
sir.
culpable homicide was defined in which section of IPC?
299.
299.
The answer. And what about voluntary causing hurt by dangerous weapons or means?
26. No.
These are all the supplementary questions. It is not there in the screen.
Voluntary causing hurt by dangerous weapon or means was defined in the section 324 of IPC. A person who voluntarily causing hurt to any person using dangerous weapon is liable to punishment under section 324 of IPC. 28th question. The basic principle which runs through section 32 to 38 of IPC is that option A, in certain circumstances, some part of the act is attributed to a person who may have performed only a frictional part of it. Option B, in certain circumstances, an entire act is attributed to a person who may have performed only a frictional part of it. Option C, in certain circumstances, an entire act is attributed to a person who may have performed the whole of it. Option D, in certain circumstances, no act is attributed to a person who may have performed only a frictional part of it. Twentieth question. Pardon?
మ్యామ్
ఎస్ ఎస్
స్క్రీన్ కనిపించట్లేదు.
ఇప్పుడు కనిపిస్తుందండి, ఒకసారి చూడండి.
Give the right answer.
The correct answer is, in certain circumstances, an entire act is attributed to a person who may have performed only a frictional part of it.
Not frictional,
Option B is the
fractional.
fractional part of it. Option B is the correct answer.
Go to the 21st second. 21st.
Yes. Which of the following is false of section 34 and section 149 of IPC? Option A. Section 34 does not by itself create any specific offense, whereas section 149 does so. Option B. Some active participation in a crime is required in section 34 while it is not needed in section 149. Option C. Section 34 speaks on common intention while section 149 contemplates common object. Option D. Section 34 requires at least 5% who must share the common intention while section 149 requires at least 2% to share the common intention.
Option D.
Option D.
Yes, option D is the correct.
Option D.
Correct answer is option D. Next question, 22nd.
Krishna, be mute.
Criminal breach of trust is dealt under option A, section 406 of IPC, option B, 407 of IPC, option C, section 408 of IPC, option D, section 409 of IPC. Direct.
Option
A.
Option A.
Option A is the correct answer. 23rd question. Dishonest misappropriation of property, knowing that it was in possession of a deceased person at his death, and that it has no since has been possession of any person legally entitled to do it, dealt under section 402 of IPC, section 403 of IPC, option C, section 404 of IPC, option D, section 405 of IPC.
C answer.
B. 404.
Madam, question 22 must be
Question
punishment for
22.
criminal breach of trust. Dealt under 405 now.
Pardon, sir?
Question 22, criminal breach of trust is dealt under 405. That there may be a question should be punishment for criminal breach of trust.
Yes, yes. 405 is regarding criminal breach of trust and 406 regarding punishment for criminal breach of trust. If 405 is not there, we can simply go for 406.
You have to pick from the multiple choice questions only, which will be the very relevant answer. Proceed.
I think 24th question. One Mrs. Komal bought a car on the name of her daughter Kiran, who is minor, and got the insurance policy transferred on her name, Mrs. Komal. The car met with an accident on 2 counts and she files for a claim on both the counts for the insurance agency. From the insurance agency, she acknowledged the receipt of the money as Kiran. The insurance company has prosecuted under section 467 of IPC, alleging fraud on the appellant's part. Option A, Mrs. Komal is guilty for forgery because she made the insurance company believe that she is Kiran. Option B, Mrs. Komal is not guilty of forgery because the said decides did not secure her any advantage as the entire transaction was that of Mrs. Komal. Option C, Mrs. Komal is guilty of forgery because she signed all the papers in the name of Kiran. Option D, both A and C.
It is about the insurance. You can make the insurance on your son name, daughter name also, even though he or she is a minor.
Yes, so the answer B is the correct answer. Mrs. Komal is not guilty of forgery because the said decides did not secure her any advantage as the entire transaction was that of Mrs. Komal. Even though she kept her minor son name, still she was doing the whole transaction.
Yes, the turn
25th
of
question.
yes, 25th question also there. Yes, go to.
Yes, sir. Under Section 98, right to private defense also is available against option A, person of unsound mind, option B, person who does not have maturity of understanding, option C, both A and B, option D, neither A nor B.
Option C.
Both A
Yeah.
and B.
Both A and B is the correct answer. Yes, sir.
Yes, now I will switch over to our Kolikonda Sharad Babu that he is going to deal today.
Thank you, sir.
Sharad Babu, turn to the Sharad Babu. Kolikonda Sharad Babu. I believe that you are present. Kolikonda Sharad Babu, are you present? Okay, till he comes now, I will deal it. First question, the code existed in Jammu and Kashmir before IPC was option A, Criminal Code for the Jammu and Kashmir, B, Penal Code of Kashmir, C, Ranbir Penal Code, D, none of the above. Which option is the right option for the first question?
C.
Option C. Ranbir Penal Code. Option C.
You are right. The C is the Ranbir Penal Code is the right answer for the first question. The second question, co-chaired first law commission in 1834, which prepared the draft of Indian Penal Code.
Yes, sir.
Kolikonda Sharad Babu, you read.
B. Lord William Bentinck. C. Lord Cornwallis. D. Thomas Babington Macaulay.
D. Thomas.
Thomas
Yes, option D is the correct answer. Thomas Babington Macaulay. Third question. The IPC came into effect in Jammu and Kashmir and Ladakh from A. 5th August 2019, B. 31st October 2019, C. 5th October 2020, D. 15th August 2019.
B. B is the right. 25th August 2019.
Yes,
B is the
option
right
D is
answer.
the correct answer.
D is the right answer.
D
Read the
is the
feedback.
right answer. 31st October 2019. And when was the Jammu and Kashmir Reorganization Act made?
Go through it.
It is supplementary question. 5th August 2019. The bill received the assent of the President on 9th August 2019, subsequent to which it was published in the Gazette of India on the same
Mamta
day.
Kaur, mute.
The notification published on the same day provided for the Union territories to come into effect from 31st October 2019. Next, fourth question. The latest amendment to IPC is A. 78, B. 62nd, C. 56th, D. 60th.
78.
Say loudly.
Just logic, you use the logic enough, you will get the answer. The latest amendment will always the latest year. What is the latest year there?
2018. 21st
Then
April.
why you are taking so much time?
Yes. Option A is the correct answer, 78th. Fifth question. Homosexuality was determined and decriminalized by Apex Court, that is Supreme Court, in one of the following cases.
B.
A.
Navtej Singh Johar versus Union of
Suresh
India.
Kumar Kaushal and
Please,
another versus
let
Naz
the
Pandey.
host will read the total D, then you can shoot. Please
You
continue.
have to follow the same technique in exam also. You have
Please
to
read all the four.
options clear. B.
Yeah, just a minute, because yes, read now.
B. Navtej Singh Johar and others versus Union of India. C. State of Maharashtra versus M.H. George. D. Kari Singh versus Emperor.
Now you shoot.
Navtej Singh Johar. B is
Option
the
B.
Yes, option B is the correct answer. Navtej Singh Johar and others versus Union of India. In the latest judgment, this homosexuality was decriminalized, no more a crime. Sixth question. According to section 47 of IPC 1860, the word animal denotes A. Any animal other than a human being. B. All animals and plants, including human beings. C. All animals and plants. D. Any living creature other than a human being.
A.
D.
Animal other than a human being.
D. Option D.
Any animal other than a human being.
No, option D is the correct answer. Any living creature other than a human
Creature and human beings.
other than a human being, according to 47 section. Any living creature other than a human being.
Go to the seventh question.
The section 45 of IPC 1860, word life denotes the life of A human being unless the contrary appears from the context. B, all animals including human beings. C, all animals, plants and human beings. D, a human being.
A answer.
Yes, option A.
Yes, option A is the correct answer. A human being unless the contrary appears from the context. Now, eighth question. Section dash of IPC 1860 says, nothing is an offense which is done in the exercise of the right of private defense. A 95, B 96, C 90, D 97.
96.
96.
B. 96.
96.
Yes.
Option B.
B 96 is the right answer. IPC section 96, things done in private defense, nothing is an offense which is done in the exercise of the right of private defense. Right of private defense cannot be said to be an offense in return. Ninth question. The punishment for defamation in IPC 1860 in accordance with section 500 is A rigorous imprisonment for a term which may extend 2 years or with fine or with both. B simple imprisonment for a term which may extend to 3 years or with fine or with both. C simple imprisonment for a term which may extend to 2 years or with fine or with both. D rigorous imprisonment for a term which may extend to 3 years or with fine or with both.
C.
Option C.
Option B.
Fine or
Yes,
both.
option C is the correct answer. Simple imprisonment for a term which may extend to 2 years or with fine or with both. Then 10th question. Section 498 of IPC defines cruelty of husband or relative of husband of a woman towards her. A, mental. B, physical. C, either mental or physical. D, none of the above.
C.
Yes, option C is the correct answer, either mental or physical.
When you read 498A, you read in the fashion 498 capital A of the IPC.
Yes. Section 498 capital A. 11th question. In the recent years, the Supreme Court asked the central government's opinion on the section related to A, criminal conspiracy, option B, death penalty, C, life imprisonment, D, sedition.
Sedition.
Option D.
Yes, option D is the correct answer. Sedition.
Participants are very excellent in the general knowledge.
12th question. Dash of the IPC as inserted in 1913 deals with the offense of criminal conspiracy. A, Chapter 5, B, Chapter 4, C, Chapter 5, capital A, D, Chapter 7.
Option C.
Option C. Chapter 5A.
Yes, option C is the correct answer. Chapter 5A is the correct answer. 13th question. When two or more persons agree to do or cause to be done, 1. A, an illegal act, or 2, an act which is not illegal by illegal means, it is defined as the criminal conspiracy as per dash of IPC. A, 122, B, 124, C, 121A, D, 128.
Capital A.
D.
D. 128.
Yes,
128.
option D is the correct answer. 120 capital A. Now, 14th question. IPC section 124 A capital A defines A, adultery, B, right, C, sedition, D, hurt.
Sedition, sir. C.
Sedition.
Option C, sedition. 15th question.
C. Sedition.
C, sedition. 15th question. In which case the Supreme Court struck down in 2018 the law of adultery, declaring it as unconstitutional and gender biased? A. Joseph Shaini versus Union of India. B. Saumitri Vishnu versus Union of India. C. Raji versus Baburao. D. Vinod Anand Lakra versus Srimati Belula Lakra and another.
A.
A, sir.
Option A, Joseph
Oh
Option
my
A,
goodness, my
Dr.
goodness.
Joseph
I
Shaini
appreciate the participants are very
versus
fast.
Union of
Now
India.
you tell me what I shown on the screen. Just I want to test your IQ. Memory.
Yeah.
Section 80.
I say what I shown on the
IPC.
image. Tell me.
It's hat touch.
Section 80 accidental act.
80, sir. 80, section 80, which talks about.
But
I
this
told you
the
what
image
I have
was-
shown on the screen. Can you tell me what is that?
It is called as hat touch. No, it's not axe. It is called as
Hatchet.
HATCHET. Hat touch.
What?
It is called as.
What about this one?
Hello.
This
Which
is X. The
Axe.
second one is X.
Yes, I appreciate. Now
Second
go to
one
the
is
16th
X.
question.
Now 16th question. A is at work with a hatchet. The
Hmm.
head flies off and
Above is
kills
called as
a
hatchet.
man who is standing by. Here, if there was no want of proper caution on the part of A, his act is A oblique N. A, offense. B, accident. C, attempted offense. D, hurt.
B accident.
B act.
Accident.
Yes,
Option
B,
accident.
accident is the correct answer. Option B is the correct answer. There was no intention on the part of A to hurt anyone or to commit offense or an attempted offense. 17th question. It is a well recognized concept of criminal jurisprudence that the exercise of the criminal jurisdiction depends on the locality of the offense committed and not upon the basis of the nationality or the locality of the offender. This was established in the case of A. Mohanan versus State of Kerala. B. Bhim Singh versus State of JK. C. Mubarak Ali Ahmad versus State of Bombay. D. Shrikantaya Munipalli versus the State of Bombay.
Option C, Mubarak Ali Ahmad.
It's I think B. I think.
Bhim Singh versus State of Jammu
JK.
and Kashmir.
Option C is the correct answer. Mubarak Ali versus
State of
of Bombay.
Yes, supplementary.
Option
What is the Bhim Singh versus state of Jammu and Kashmir?
He belongs to Panthers party. He died recently. Illegal.
I see what the principle is used over there.
Wrongful
Habeas
confinement.
corpus.
False imprisonment and Article 21. Habeas corpus. State liability. The police high-handedness. 15,000 compensation to be paid by the state. So the state could not do again such an activity. And he is a Bhim Singh is a MLA. He does not allowed to go to the assembly sessions in Jammu and Kashmir. Go to the 18th question.
18th question. It was held that a chief minister or a minister is in the pay of government payroll and therefore public servant within the meaning of section 21(2) of IPC. A. N. Sanjeev Reddy, Neelam Sanjeev Reddy versus Union of India. B. Karunanidhi versus Union of India. C. Gyani Jail Singh versus Union of India. D. Jayalalitha versus Union of India.
Option B, Karunanidhi versus Union of India.
Yes, option B is the correct answer. Karunanidhi versus Union of India. 19th question. This is a landmark case of a naval officer who was put up on trial under section 290 and 304 of part 1 of the Indian Penal Code IPC for alleged murder of his wife's paramour. The earlier court acquitted of him by a jury trial was dismissed by the High Court and convicted the accused to life imprisonment under section 302 of IPC. Supreme Court also upheld the verdict. The case is A. R versus Cheeseman. B. R versus Bishop. C. R versus Mrs. Telson. D. K.M. Nanavati versus State of Maharashtra.
D. K.M. Nanavati.
Nanavati versus State of Maharashtra.
Yes.
Supplementary
D,
question.
correct answer. K.M. Nanavati versus State of Maharashtra.
Why the KM Nanavati versus State of Maharashtra is also famous for another?
It was the last jury.
Yes, Venunad is the
Jury
correct.
system was ended up.
Sir, it is a last jury case. And what is the principle involved over there? Can the provocation is considered, not considered? Provocation is not considered because he shot the paramour the second day. Next, 20th question.
Yes. Next question. 20th question. A. An officer of Court of Justice, upon ordered by the court, arrests Y after due inquiry, believing Z to be Y. Arrests Z. A has committed A. Offense, no offense, D. C. Assault, D. None of the above.
B.
A
No
offense,
offense.
offense, sir. B, no offense.
B. No offense, just he
A
mistook
offense.
only. Believing Z to be Y, arrests Z. So that's why there was no offense, and that was according to order of the court. 21st question. In one of the following cases, two friends who were fond of wrestling were wrestling, and one got thrown away on a stone and died. This was held to be an accident, and since it was not done without any criminal intention, the accused was acquitted. The case is A. Jogeshwar versus Emperor. B. R versus Stock. C. R versus White. D. Chanda versus Rex.
Option A.
Shoot, no negative marks.
Option
Yes.
Yes, sir.
Option D is the correct answer. Chanda versus Rex.
Okay,
That is
sir.
the correct answer for this question, 21st question. Next, sir. 22nd question. Section 80 of IPC, in other words, nothing is an offense if it is committed which is odd man out. A. By accident. B. Without criminal intention or knowledge. C. While doing an unlawful act. D. In a lawful manner.
By accident.
In a lawful manner.
D, in a lawful manner. Option C, while doing an unlawful act. D.
No, D.
Option A, sir. Section
In a lawful manner.
How
Section
could you
A.
say that by doing an unlawful act, it is not an offense? A doing unlawful act is an offense.
No.
So what is the right answer? Odd man out.
By accident, A. Option A.
Accident is a section A.
Check. Option C is the right answer. What is the odd man out is? Odd man out
You
is
have to pick out the odd man, which is not
connected to the
relevant to it.
section 80. Okay, now it is my turn. I will give you the, it says Zawadi. Zawadi means gift. G-I-F-T, gift. What is the gift? I can make a clap, C-L-A-P, clap, if you give the right answer. Which one is correct or exact style or method writing the IPC 1860? A, the Indian Penal Code 1860. B, the Indian Penal Code 1860. The Indian Penal Code 1860. D, the Indian Penal Code. Anyone? The correct style.
C.
Sir, let me check the smartphone, then I will tell you.
Option B.
Time is up. No one is got a clap. Even myself only clap myself. Which one is the right answer?
C.
Option C.
Option B.
Option B.
The Indian.
Option
See,
B.
I am showing the proof. I am showing the proof.
Option A.
So now you tell me which is the right answer.
Option D.
Which is the right answer?
B.
D. Option D.
D.
B is the right answer. The Indian Penal Code. Yes, in the style. Please, those who could not speak, please mute it. Otherwise, I will get the resound and disturbance also. Because everything what is said, you said, I said, anyone said, it will be recorded. Because I will send you the link of the YouTube as soon as the class is over, after loading, after editing, and after loading it. Now you can tell me, how many chapters are there in the Indian Penal Code?
23 chapters.
23 chapters.
I appreciate. Let me check it whether it is true or not.
511 sections.
Yes, there are 23 chapters are there. It can make. Okay, now.
511 sections.
Okay, now. Okay, listen me. Correct. It is correct. I said. Listen me. Mute. Shravanti, mute. When you want to speak at the time, you speak. Now I will give the facts of the case law. Shravanti, mute. Okay. Now I will give the facts of the case law. Participants only should have to give the answer, not the host. The facts of the case law is, there is either you can say shipwreck or a boat wreck in the sea. Only one plank is left over there. And there are 4 persons are left. Among the 4, one is the minor. The 3 of them planned and killed the minor because they are starvation to death. And they ate the flesh of a minor. And they reached to the, using the plank to the shore. And the case is filed. Can it will be the necessity to kill a younger boy? Now you tell me, what is the name of the case law? I said participant only should speak, not the host.
R versus Tolson.
And Stephen, sir.
R versus Tolson, please.
Dudley versus Stephen.
Dudley and Stephen, sir.
Yes, I appreciate. R versus Dudley and Stephen. Then who was killed? Can you tell me the name? Who was killed, the minor? His name is Parker. And who is the 3rd person who is not guilty? If you are not mistaken, is the Brooks. Now you tell me, R versus Dudley and Stephen. R stands for what? Anyone? Not the participants only should speak, not the host.
Queen?
R stands for what? You gave the answer. R versus Dudley versus Stephen. That is the answer you have given. And here I am writing R versus. I said only the participant should have to speak, not the host. Say
Reg.
After checking the smartphone, then what stands for here? I magnify it so that you could see it. Is it visible? Is it visible?
No, sir.
Yes, sir. Yes, sir.
I could know that whether it is visible or not because I have the screen here. I shared, I can see. R stands for what? Sir, we are checking the now, sir, smartphone. Time is up. So R stands for, there are 2 things are there. Number 1, what do you say king in Latin terminology? What do you say king in Latin terminology?
Lord.
Emperor.
Rex, Emperor.
Rex.
Rex.
You say? It is
REX.
Rex means king.
Emperor. King.
King, don't say emperor.
Okay.
Then what do you say queen in Latin terminology? Only Professor Hussain students can give the answer. S.R. Venunath, I would expect the answer from you.
It's REGINA.
Yes.
Regina, sir.
You check. Anyway, that you checked it. You should be very much cautious enough when you want to pronounce Regina. So here R stand for Regina versus Dudley and Stephen. This is the full form of R. Even after 32 years of teaching, I did not came to know, and I came to know only 2 days back that R stands. I was in the impression R is Rex, but when I searched it, then I found it is the Regina versus Dudley and Stephen, and there is no necessity, and it is purely a murder case. Is it clear?
Yes, sir.
Okay, now necessity, whether is a difference in the law of tort.
Yes, sir.
There is a famous case law is there. I have forgotten the case law, but I will give the facts of the case law. If I remember, I will give the case law name also. The ship, we can say, what is the another synonym for the ship in a polished terminology?
Vessel.
Vessel. A vessel carrying the cargo, crude oil, from one station to another station. But there was a turbulent water is there, and the very ship is going to be sunk. At that instance, they have thrown the oil into the sea, and the oil is reached by the waves to the shore, and the shore, there would be a beach. The people could not enjoy the beach, and they filed a case against the person, those who have thrown the oil into the ship, oil into the sea. Now you tell me, there is only one word is there, throwing the luggage or weightage from the ship into the sea to lighten the ship so that the vessel will not be drowned. Can you tell me what is the one word? I say only the participants, not the host. I repeat, throwing the cargo into the sea to lighten the ship so that the ship cannot be drowned. And the necessity defense is valid there. The necessity defense is valid there. So the only one word we can say, yes, now it is given the chance to the host. Your host can give the answer now.
I think it is buoyancy.
No.
It's Jetsam.
I wrote
Jetsam also.
I wrote on the screen.
That's correct, but you can also call it Jetsam in English.
Yeah, but generally the word you said jettison. And forget the case law name. That is the English case law, but I could remember it. It is the I could not remember the case law. It is the necessity is there. Now the another point I would like to share with you. In the self-defense, suppose somebody has thrown a stone from the 7th floor to the man who is on the ground floor. And the ground floor man can take out the AK-47 and shoot at him. Is it a self-defense?
No.
Unreasonable amount of self-defense.
Only participants should have to speak.
No, sir.
No.
Defense.
Then what is the appropriate word that could be used over there?
Reasonable force.
No. Proportionate force. Proportionate force, you could use it. Suppose if a person has thrown it, you cannot take the sword and chop off his hand. It's a disproportionate force, you can use it. And hence it cannot be said to be a self-defense. And the defense will not be applicable over there. Now you tell me, because you read the contract, you read the tort. Is it or not? What is the famous case law where it can make the distinction between a contract and a tort? There are two cases are there. In contract, one case, in tort, one case. But both the things comes under the contract only. But it is not out of the contract. It is amount to tort. When your tort is there, it is your minor can be held liable. But in the contract, a minor is not held liable. The famous case law is
Meher Bibi versus
Moheri Bibi versus Dharmadas Ghosh. But now, I'll give you a hint also. And the child hide a mare. I said mare, M-A-R-E, mare. Means M-A-R-E, mare means
Female horse.
a female horse. I should have to give the participant to give the chance, not the host. When I say host can also give the answer, then you can. Okay, it doesn't matter. At the time, they specifically mentioned over there, but this fellow has given to another. But consequently, the horse died or horse injured. And they filed a case against the child. And what is the name of the case law where the child is not liable under contract? Participants, if participant failed, I can give the chance to the host. Yes, host?
No, sir, I too don't.
Jennings versus Randall. J-E-N-N-I-N-G. Jennings versus Randall. R-U-N-D-A-L-L. Randall. That is the shows a distinction between a contract. Then when you come to the tort is concerned, what is the case law? There also the Mary has taken, they specifically they mentioned they should not use for the lurking or jumping, but he has given to the somebody else and he used for the lurking and jumping, the consequently horse died. Even though it is not arising out of the contract and hence a child is held liable under tort. What is the name of the case law? Participants, this is a famous case law. When you are any person who is teaching the tort, without teaching it, he cannot move. Bernard versus Haggis. B-U-R-N-A-R-D. Bernard versus Haggis. H-A-G-G-I-S. Now I will come to the another case law, where the special damages are awarded or not awarded in the contract. Can I tell the name of the case law? Can I tell the facts of the case law? Choose.
Hardley versus Baxendale.
Yes, I appreciate. A clap to you. Hardley versus Baxendale. A work given to the individual contractor, but still the owner is held liable to pay the compensation. What is the landmark case law? Hint, strict liability. Now you tell me the name of the case law. Participants.
Famous case law. Uska घर का पानी, I forgot it.
Rayland versus Fletcher.
Rayland versus
Yes.
Fletcher.
And how many exceptions it is having? 5 exceptions.
5 exceptions.
Now the concept of the Rayland versus Fletcher is changed or not?
Yes. MC Mehta versus Union of India. Absolute.
It is started in the oleum gas case law first. Shriram Textile oleum gas case law, but it is consolidated in the Bhopal gas tragedy case law or MIG case law. The name of the MIG case law is Bhopal gas tragedy case law is?
MC Mehta versus Union of India.
Union
No.
Carbide.
No.
Bhopal gas liquid.
Union Carbide versus Union of India. Of course, later on we can make it the Union of India versus Union Carbide of Union of India versus Union Carbide. There it is changed. No more strict liability, it is in absolute liability. Absolute liability concept is generated in India only. And hence, everybody knows in the world the Bhopal gas tragedy case. What is the gas?
Old gas.
I said Bhopal gas tragedy case law.
Methyl isocyanate.
I told you MIC, MIC, methyl isocyanate. That is the case law which is very much famous. Now, if you supply the necessities to a child, the person who supplied the necessities can be reimbursed. Now you tell me the case law name or the facts of the case law. A necessity supplied to the child is reimbursed. Okay, I will give the hint. Taylor case law. 3-piece suit case law. Now you tell me. Yes? Say pass on. If you could not know it. Iman versus Nash. Nash versus Iman. I think this is the case law. Nash versus Inman. I-N-M-A-N. Nash versus Inman. And where 3-piece suit. What is meant by 3-piece suit? Anyone? Except S.R. Venunath. He knows what is 3-piece suit. Anyone, what is meant by 3-piece suit? Still, at any time it will be stopped because time is up. What is meant by 3-piece suit? Anyone? Say pass on. If you don't know. Pass on.
Pass on.
Pass on, sir.
3-piece suit. Verunath, tell me now.
Yeah, it consists of blazer. First thing. Second one is your inner waist. Third one is a trouser. Same color.
But generally we don't say, can you say blazer? Can you say coat?
No, there is a difference between a coat and a blazer.
Okay. What about the inner? Inner is called, there is a specific name is there for inner.
Waistcoat.
Waistcoat. W-A-I-S-T, waistcoat. And trouser.
When you have a
pant.
when you have a three-piece, all the colors will be the same.
Yes,
the
yes,
coat,
yes.
The inner one and the trouser.
Yes, yes.
But the blazer is something which is contrary to the pant and your shirt, what you're wearing it.
Okay. I admit. What your explanation is.
How it is related? How it is related to?
Generally, 3-piece suit means coat, trouser, and waistcoat of having the similar color. But when you're wearing the waistcoat, the back is only lining is there, not the cloth is there. Because that lining and the coat lining will combat each other. The compatibility is there. Okay, forget about it now, because we know the case law, Nash versus Inman case law. Now, intention to create the legal relationship. Number one, what is the famous case law? Intention to create the legal relationship. I can give the hint. Yes? Say it loudly.
Balfour versus
Balfour versus Carbolic Smoke Ball Company Limited. It is not a puff. Intention to create the legal relationship. Hence, they deposited the amount in which bank?
But this comes under the contract, no?
Yes, contract.
This case law? Yeah, but I think that's why I'm a little bit confused. How come contract has come into IPC?
No, it's the contract. That is It is not a puff. And hence, and he has deposited in the Imperial Bank. If anybody use the carbolic balls, what will be disappeared? Cancer. What will be disappeared?
Influenza.
Influenza. Okay, now I'll come to the another point. Where and how it can be made. Privity of contract is fallacy. Even though a party who is not in the contract can be sued under the negligence. A famous case law in the contract, in the tort.
Dunlop Pneumatic Company.
That is the
Dunlop
contract.
Pneumatic
Dunlop Pneumatic Company versus Selfridge Company. A Dunlop Pneumatic Company cannot file a suit against the Selfridge Company because Selfridge Company is not a party to the contract. It's a due company is the party to the contract. But when the matter comes to the tort, what is the case law? Can I give the hint? Snail in the tumbler, poured in the second round. The fancy got nausea. She admitted in the hospital.
Donog versus Stevenson.
That is the first given the chance to the participants. When I say host, the host should come into the picture. That is the case law is Donegal versus Stevenson. What is the Donegal versus Stevenson shows? The three principles. What are the three principles? First, participants. If the participants will not given, then I'll say host. Say pass on. Participants. Okay, now host.
The remoteness does not apply, sir.
One principle is love your neighbor. Neighborhood principle. Number one. Number two, privity of contract is fallacy. Number three, novus actus intervenus. There is no break of chain. If the break of chain is there, yes, who broke the chain, he will be held responsible. Otherwise, manufacturer is held responsible. Here the break of chain is not
At
there.
the time of manufacture of the beer itself, the snail was there in the...
Yes, because no one has put the snail. What type of the snail it is? There is the adjective is given. What is the adjective for the snail in front? Anyone? Either you can say rotten snail, or you can say decayed snail, or you can say decomposed snail. What is the bottle? The nature of the bottle.
Decomposed.
The nature of the bottle.
Decomposites.
I say bottle. B-O-T-T-L-E, bottle.
Ginger beer.
I say bottle, nature of the bottle. I said, did not say content of the bottle. Opaque. O-P-A-Q-U-E means it is not a transparent, nor it is a transculent. Neither is it transparent, nor it is a transculent. Transculent means middle we can see. It is opaque, completely not seen from the outside, and it is a sealed bottle. And hence, now you tell me, I am asking only for the participants here till it will be closed. What is the trio maxims in law of tort? I am asking only to the participants. What is the trio maxim in the law of tort? T-R-I-O, trio maxim. Three maxim. Trio means three. Say pass on, then I will go. Yes, now, host.
Damnum sine injuria, injuria sine damnum,
Injurious and damnum.
ubiges ibi remedium.
Now, what is the famous case law? A injury is caused without a legal damage. Participants,
Wayland versus Fetcher's case.
I said once again,
Wayland versus
there was an injury is there, but no damage is
Beam Singh
caused.
versus Beam Singh versus State of Jammu and Kashmir.
Wrong. That is a state liability. A person
Beam Singh
wants
versus
to
Ashby
State of
versus
Jammu
White.
and Kashmir.
Ashby versus White, a person wants to use his franchise, but the presiding officer did not allow him, but to whom that he would like to elect, he won with the bumper majority, and there is no damage is caused or, but his legal injury was there because he was having the right is infringed. Now, damnum sine injuria, a damage is caused without legal injury. What is the famous case law? Only participants.
Gloucester Grammar School.
Gloucester versus Gloucester Grammar School case law. What is the spelling for the grammar?
GRAMMAR.
Wrong. Anyone? Anyone? GRAMMAR. I repeat, or you repeat.
Grammar school.
You repeat.
GRAMMAR.
GRAMMAR.
Don't say MM. GRAMMAR. Grammar. That is a very famous case law where we can make it out. Either you say the contract or you say the tort. Now another case law that I will mention it. Border Security Force, they collected the firewood and they cooked the food because their gas is exhausted. And the owner of the firewood filed a case against the government. What is the name of the case law? Border Security Force, BSF. They entered into somebody's land and collected the firewood from that land without the consent of that person. And they cooked the food. And they say it's a necessity. What is the name of the case law? Participants, next, host.
No, sir, I too don't.
Ruplal versus Union of India. Ruplal versus Union of India is the case law where the state is liable to pay the compensation and the offense committed is, what is the offense committed in it? There, anyone?
I think it is trespass.
Okay, I have it is a trespass to land, number one. Number two, trespass to goods. But what is there is a particular name is there for the case law. A particular name is there. Say pass on, I will give the answer. Say pass on, I will give the answer.
Pass on, sir.
Conversion. CONVERSION. Now you tell me, in Latin terminology, king can do no wrong. I repeat, king can do no wrong. Say in Latin terminology. If you don't know, you say pass on.
Pass on, sir.
Rex Rex ex
Rex non est peccare. The king can do no wrong. Whether a state is liable in India where there is any act for the state liability. In England, Crown Proceeding Act is there. In Tanzania, Government Proceeding Act is there in Tanzania. In USA, there is a federal, I forgotten, just a minute, Federal Tribunal Act, no. But some act is there in the USA. Whether any act is there in India? Answer is capital N, capital O.
No.
No. Then how the state liability cases are decided? Based on section, based on precedent, based on the violation of the right. Now the distinction between the sovereign and non-sovereign function is narrowed down, because laissez-faire, social welfare state, hence state will work like an individual. So we can sue the state like an individual, but still there is the immunity is there for the state. Can you tell me the one case law of Andhra Pradesh where the state is held liable? I'm speaking about the Andhra Pradesh at the time. I will give the hint also. In the prison, they told that people, opposition party will hurl the bombs. A security should be given more. But the government did not pay the heed, and the people thrown the bombs, and consequently the prisoner died. What is the name of the case law? It's a AP case law at the time. It's a state liability case law. Challa Malakonda Reddy versus State of AP. The state liability case law. Is it clear?
State was held responsible, sir, and
Yes,
held
state is held
liable
responsible, and because
liable and pay compensation was paid.
yes, it is compensation will be given over there. And we have the cases where we can say, in some cases state is liable, in some cases state is not liable. For instance, there is another case law is there, but I forgot the name of the first name of the case law, but I could remember it. That is the state of AP. Nagarjuna Sagar Dam was constructed over there. But the percolation of the water is spoiled or damaged the roots of the orchard, that is the lemon orchard. And he filed a case against the state of AP. The state say, your orchard is spoiled, but the anicut or the bun or the project, it is for the irrigation. Minors will be suffered, majority will be benefited, hence no liability would be there for the state.
Collateral damage.
Yes, he will not get any damages, even though his orchard, that is lemon orchard, roots are spoiled because of the high percolation of the water and the roots were died. So this way that we have so many number of cases, sometimes they will ask directly the case and what are the principle held in that case law, they may ask also. Now you tell me, preamble is not part of the constitution. In which case law it is decided?
Keshavananda Bharati was the state of.
You please listen carefully the question. Preamble is not the part of the constitution. In which case law it is decided? Beriburi case law. And the preamble is the part of the constitution, as you said, Keshavananda Bharati case law. What is the another name for the Keshavananda Bharati case law? Nickname? Say pass on, I will give the answer. Say pass on, I will give the answer.
Pass on.
Fundamental rights case.
Basic structure case law, or we can say fundamental right case law. Is it clear? Now, in the constitution, which article is the heart of the constitution?
32, sir.
Article 32.
32, sir.
I appreciate. What it deals?
Constitutional remedies, sir.
What it deals?
Writs.
Say writs. How many types of writs?
Habeas corpus, mandamus, prohibition, censure, and covenant, sir. 5.
They will may ask also in the left hand side, they will give all the 5 writs. In the right hand side, they will give in the jumbled order. They will say, match the following. Is it clear? Say yes.
Yes.
In constitution, where the state is defined, in which article?
12, sir. Article 12.
Article 12. Which article is called Pandora box? I repeat. Which article is called Pandora box? Pandora Pandora box -box box. Say pass on, I will give the answer.
Pass on, sir.
Article 21. Now you tell me. Of course, for general law, even though it is not there, family law is not there, I believe. The triple talaq is unconstitutional, they said. In which case law?
Shaira Banu.
Versus?
Union of India.
Yes, that you are supposed to say that thing. Can you tell me that case law? Voyeurism means a person doing an act, a sexual act, people will peep it. Or changing the dress, the people will peep it. Can you name the case law? Voyeurism.
Any person who's taking a picture,
Yeah, even picture also.
That's what I'm saying. Any person who takes a picture, seeing a person who's doing an act privately is called voyeurism.
Yes.
D54C of IPC.
In which state the first case law it is noted? In Goa, there is a shop and where they fixed in the dressing room the camera. I have forgotten the lady name. She is a very much famous lady. She filed a case under public interest litigation.
Smriti Irani?
Yes.
Smriti Irani.
You are right. You are right.
That is Fab India Limited. The dress. This is Fab India.
Okay.
He's a union minister.
It's a highlighted case law.
Yeah, Fab India Limited.
And what is the Vishaka case law says?
Sexual harassment against women in office, workplace.
It is applicable only to the citizens?
No. What do
It
you mean
is
by citizen?
applicable to anyone because the lady who was sexually abused belongs to
Gujar community. Anganwadi worker. Anganwadi worker.
Bangladesh.
No. Rajasthan.
Rajasthan case law is there. Now, another is Bangladesh. That is the case law where the railway in Calcutta, the railway employees sexually abused her. This is another case law. So I am giving only the curtain riser regarding the penal code provisions are concerned. Some of them I mixed in the contract cases. Some places I missed the tort cases. And I don't know whether they have forgotten today to close because it's a 50 minutes only free. After 50 minutes, it will be stopped automatically.
Okay, I have one question.
Yes, please.
Where it is written about the basic structure in Indian Constitution?
Repeat.
Where it is written about the basic structure in the Indian Constitution?
They only explained the basic structure in the Keshavananda Bharati case law.
And what are the three elements of basic structure?
They said the review, it cannot be changed. Judicial review is there, is the basic structure. Judicial review. And I don't know the other two. If you have an idea, please contribute.
It is justice, equality, and rule of law.
Okay.
That is the basic structure of Indian Constitution.
That is in the preamble.
Yeah, if you read Keshavananda Bharati entire case law, which runs into I think 100 pages something. If you read the entire Keshavananda Bharati case law, you'll get it.
I appreciate. Justice.
Anyway, after 20 years, I'm hearing to you. I was a student in 94.
Yes,
I completed my LLB in 97, then LLM in 99. I think after a gap of 20 years, I'm hearing you.
You are right. So in the IPC, now I will let you share my view. IPC, because there are 4 types of abbreviations are there. Among them, number 1, initialism. Number 2, acronym. Number 3, shortening. Number 4, contraction. There are 4 types of the abbreviations. Repeat. Number 1, initialism. Number 2, acronym. Number 3, shortening. Number 4, contraction. When you come to the matter of the IPC, where the letters were pronounced separately, IPC, can you tell me whether it is initialism or acronym or shortening or contraction?
B, acronym.
No, it is initialism, where each word will be pronounced separately, like USA, initialism.
In the same case, what we say for CPC also.
Yes, same. But when you come to the acronym, now I will give the example of acronym. NATO, OPAC, CAFEPOSA, ICRISAT, ISRO. Now you tell me, I did not pronounce ISRO, but I pronounced as a one word. When the first letters of the word will be taken together without the punctuation and pronounced as a one word, then we can say it's the acronym. Is it clear? Then come to the matter of the abbreviation. When you're writing the February, you need not to write the February full. You can write the F capital letter, E small letter, B small letter, and full stop. That is the
abbreviation.
Shortening. No, all 4 are abbreviations. All 4 are abbreviations. But the kind of the abbreviation is shortening. SHORTENING. And the last one is people use it in SMS. When you write I cannot, you don't write I cannot. But what you write? You write in this fashion.
I can't.
I will show you you write in this fashion. ICANT. and T. What is the symbol I put it over there?
Apostrophe.
Apostrophe. First chance will be for the participants, next chance for the host. It is an apostrophe, and that is called contraction. So now, how many types of the abbreviation you learned from me?
4.
In addition to the Indian Penal Code, IPC.
Sir, one more thing I want to add is in case of acronyms, sometimes some words are omitted, so that if it is easy to find a word, 1 or 2 words are omitted in the whole group of words. 1 or 2 words are omitted, so that if it can make a word which can be pronounced.
Example
That
like
is also
psychology.
there in acronym.
Yeah, even a jumbled words are there if you can make it out, because our mind is fixed in such a way, even though you missed some of the words, or you puzzled words are so jumbled also, you can make it out. Our mindset will read in a correct manner. But I forgotten that there is a specific name for that one. Even though a jumbled word would be there, we can read in a proper form. Okay, now let us stop my today's class, and tomorrow I already posted that what we are going to deal tomorrow is what we are going to deal tomorrow.
Hindu
you have a
Marriage Act and
schedule?
Succession Act, sir. Hindu Marriage Act and Succession Act.
See, I shared it on the screen now. So it is 23rd 7 2022 Hindu Marriage Act ampersand, that is the symbol, equivalent is English is and Succession Act. So with this, I would like to thankful to my first host, and the second host. What is their name? Sri Vidya Motamari is the first host, and Kolikonda Sharat Babu is the second host, and Sri Konda Sharat Babu, he is hosted from the USA, San Francisco, and Motamari is from Khammam, India, and I am from
Tanzania.
Mwanza, Tanzania. So thank you very much for patient listening. We'll meet you tomorrow on the same timings. Now I will stop my today's lectures with this. I will wind it up. Asante Sana, thank you very much. And see you tomorrow. End of the meeting for all.
Thank you, sir.
End
Thank you.
meeting.
विंध्य हिमाचल यमुना सारे जहां से अच्छा हिंदुस्तान हमारा। जय हिंद।
जय हिंद।